My name is Bob Gasparo. I'm an estate planning and elder law attorney with an office in Haverford, Pennsylvania. As a result of drafting Pennsylvania wills for decades, I've learned what does and what does not work. This short course will give you enough information to draft a valid Pennsylvania will. It won't be as good as if it was drafted by a licensed attorney, but it will work. So now, let's get on the Pennsylvania wills. In this course, we're going to cover the mental state that you need to make a will. We're going to go over the mechanics of drafting the will, and then the mechanics of signing the will. And I'm also going to present some examples. First, do you have the correct mental state or mental competency to make a will that can survive a will contest? The competency to make a will in Pennsylvania is different from the legal competency in a civil or a criminal matter. In Pennsylvania, you're competent to make a will if you're over age 18 and of sound mind. Now, judges will often say that you have a right to make poor decisions, but that doesn't mean you're not of sound mind. In fact, according to Pennsylvania cases, all you need for sound mind is three things. First, you have to know those persons who are the natural objects of your bounty. Second, you have to know the property that makes up your estate. And third, you have to know what you want to do with your estate after you die. So a failure of memory does not necessarily constitute unsound mind. In fact, a person with mild or even moderate stages of Alzheimer's does not in and of itself lack testamentary capacity. Although, as we will find out later, witnesses aren't required to make a valid Pennsylvania will, a presumption of capacity arises if the will is signed by two witnesses. Just remember, they have to be there when you actually sign the will. So other than the requirement that you're over 18 and of sound mind, the only requirement for a Pennsylvania will is that it be signed at the end by the maker. That's it. That's right. Your will doesn't need to be witnessed or notarized or even typed up. It only needs to be signed at the end. Now, Pennsylvania courts have held that although it's a good idea to dispose of your entire estate by your will, it's not necessary. And also, although it's a good idea to appoint an executor, that's not necessarily either. But one thing you should be aware of if you're married is that you can't disinherit your spouse. He or she is entitled to at least 1/3 of your estate by law. Another thing you should be concerned about is the condition of your signature. If you've been in the hospital for a while, or you're under medication, or your hand is in a cast, your signature might not resemble your normal signature, and that could turn out to be a problem. If you cannot make your normal signature, then you can make your mark as a substitute. In that case, you have to make your mark before two witnesses. But if you can make your signature as you normally do, there's no need for witnesses. It might not look exactly like any other signature that you make, but a good handwriting expert will be able to verify, and it would survive a will contest. And don't cross things out or change them in your will. If you want to change things, you're better off writing a brand new will and signing at the end. And of course, you're going to want to put the date on each will that you make up so that we know which one is the most recent. So now, let's do it. I suggest that you place today's date on your will and state that you intend it to be your last will and testament. Next, you can appoint an executor to handle your estate when you die. It's not required, but it might save some time and expense. It's up to you. Next, if you own anything that you want to go to a particular person, then say so. There's no limit to how many paragraphs or pages you can use for this, so don't be shy. Finally, decide what happens with what's left in your estate after you give away those prior things we just mentioned and after the expenses of a probate are paid. Divide it up by percentages if you want. So you could give 100% to your spouse, or you could give 50% to your spouse and 50% to your brother. Or You could divide it 25% each among your 4 children or your 4 closest friends. And finally, sign your will at the end. There, that's it. You have a valid will now. And as I said in the beginning, this will is not as good as one drafted by a lawyer, but it's legal and you can do it in just a few minutes, so do it now. In the past few minutes, I've given you the foundational information you need to start creating your very own simple will. But drafting a comprehensive and effective will involves more than just the basics. As I've stated before, I strongly recommend that you consult an attorney to finalize and execute your will. However, I also recognize that many people face the same common challenge or barrier, and that is how to make the most of an attorney's services without incurring excessive costs, because most people can't afford to pay over $350 per billable hour, and that's what most attorneys charge these days. However, on the other hand, for me or any other attorney to explore every possible option and detail you could use in your will would take upwards of 5 hours. At an average billable hour of $350 per hour, that's over $1,700 even before the actual drafting begins. Now, although some attorneys charge these fees and there are some people who can afford them, this makes the process unaffordable for many others. So to address this issue, I've written a book that's designed to empower you. It's a step-by-step guide to creating a will that reflects your true intentions while also protecting your loved ones. This book, which currently costs below $50, is written in clear, easy-to-understand language, where I try to simplify complex legal terms. It's designed to include all the forms and other information you'll need to get started in drafting your will. Now, let's be clear. The book is not designed to be read in one sitting. But if you take the time to read this book over several days or weeks, you'll gain the knowledge to take control of the process, significantly reducing the time and expense of legal consultations. The book is packed with expert tips designed to help you avoid any common mistakes, from the most serious mistake of accidentally invalidating your will to the lesser mistakes such as inadvertently causing family disagreements or animosity. The book explains different and creative ways to leave property and the tax implications of each option. For example, in Pennsylvania, the Pennsylvania inheritance taxes range from 0% to 15%, depending on how you distribute your property. If you're not familiar with Pennsylvania inheritance taxes, this book could easily pay for itself several times over. In the book, I also cover the use of trusts. These can be a powerful estate planning tool. Trusts are an excellent way to provide for minor children, to provide for beneficiaries who may need help managing their finances, to care for your pets, or to create a lasting legacy for your family. You can set up a testamentary trust in your will, which takes effect upon your death. Now, with this book to guide you, you'll have the resources, I hope, to draft a will that's tailored to your unique needs and which is also specific to the state of Pennsylvania. And hopefully, the forms which are included in the book are enough to cover the cost. So why did I write the book? Because my goal is that everyone in the Commonwealth of Pennsylvania have a will. And although we don't like to spend too much time thinking about it, each and every one of us will die someday. So why not use that very sad event as a chance to add meaning to the life of those who survive you? That's the holistic approach I've taken in this book. If you're interested in the book, you can order it using the link in this slide or the link that appears in the comments below. Thank you.